chapter, because there's only two real problems in there, and they're not that complicated. But we want to talk structurally about fees and what that means, because that is the paradigmatic example of the lawyer's self-interest against the client's interest. And it sort of goes back to our discussion previously about, when we first started the course, about the components of the attorney-client relationship. Money always gets in the way, of course, and that's what we're looking at. A tremendous amount of discretion upon the lawyer's part, and we have to make sure we don't take advantage of the client, because that undermines all the other interests that we're talking about. So we're going to spend most of our time today talking about Rule 1.5, go through that, and then Rule 1.8, which is interesting. That's probably the only other time, apart from a contingent fee, where the lawyer can gain a stake in the outcome or litigation or transaction. 1.8 is set up in such a way as it discourages you from entering into a transaction with the client, but if you must, 3 writings are required. You know, the terms have to be fair and reasonable to the client. That has to be in writing. You have to inform the client that he or she should seek independent legal counsel. That should be in writing. Give them enough time to do that. And then finally, the agreement itself, or I should say informed consent, has to be in writing as well. So 1.8 starts off, we're going to see shall not enter into this relationship, but if you must, here's what you have to do. It says unless. And so that's what we'll do. Well, I want to review a little bit of what we did in our last class. We started talking about conflicts between lawyers and clients, and then this is going to set up our discussion about an unreasonable fee. So we know that the fee has to be reasonable. Fee has to be reasonable, and we used a number of things to make that determination. We didn't necessarily say there is no sort of numerical coefficient in the rule or anything that says this is a reasonable fee. You notice under 1.5 there are all of these factors, and those factors are in there for 2 reasons, both to sort of give us some parameters about the scope of a reasonable fee, and it allows the attorney some discretion in setting that fee. One thing that really jumps out at you in 1.5 is that it doesn't say that it has to be in writing. The factors, it just says the lawyer shall not make an agreement for charge or collect an unreasonable fee. And so in determining this, we saw in our last class, there are different things that we look at. How does a lawyer know if the fee is unreasonable? You know, we look at these factors, 1 through 7. I'll just say C factors. And that's not an exhaustive list. Time and labor, preclusion of other employment, customary fee in the locality where the practice is happening, time limitation, relationships. You know, this attorney and client may have a previous relationship, and it may seem really high, but this is what they always do. Sophisticated client, reputation of a lawyer. And so notice this. Also, whether the fee is fixed or contingent. I should put that up there. That's 8. So this goes all the way from time and labor all the way to whether it's a fixed or contingent fee. But notice this. Preferably in writing. So notice that. And this is really important, scope of representation. I mean, we made a really big deal about this when we're talking about the communication between an attorney and client. I mean, that's the bedrock of that relationship, knowing what you as the agent of the client are supposed to do. And it just says when we determine this fee, we look at these factors. Preferably in writing, we come to some agreement about any scope of representation. And then also just a little throw off, we can even change the fee. We're charging $800 more this month. The only thing we have to do under this rule is any changes in the basis or rate of the fee or expenses shall also be communicated to the client. I guess that's preferably in writing too. So then you go down to letter C, we talked about, and that talks about a contingent fee. Contingent fee shall be in writing. And I guess the distinction there is this is an instance where the lawyer will have some stake in the outcome based upon these percentages, and we want to be clear that the client knows that. So you see a number of things. That has to be in writing, has to be signed by the client. You have to state the method in which the fee is determined, including the percentage. You also have to tell the client whether expenses are to be deducted before or after calculating the fee. If you do the calculation of expenses before, those expenses are deducted from the client's recovery. The lawyer gets more money up front, client gets less. We're going to see this on a little chart in the book. If you do it after, the client receives more if expenses are deducted after the lawyer's fee is calculated. So contingency fee has to be in writing. And then another point that we made is that contingent fees are prohibited in criminal cases, and divorce. And then E talks about the lawyers not in the same firm may divide fee, assume responsibility or proportionate work. So that's pretty much what we looked at when we talked about a reasonable fee in our last class. And so we're going to jump over to page 381, an unreasonable fee. And we did a number of things. Before that, we looked at the Fordham case. You see that on page 375. That fee was excessive. Notice we looked at all those factors. Even though we got a good result, we were paying for the lawyer to get up to speed. We don't do that. And so we have a scenario where we're always trying to look at the reasonableness of fees. We also looked at, on page 378, that tobacco company litigation, where the tobacco company was entitled under the agreement to $2 billion. But everyone sort of scoffed at that. It was too much compared to the $20 million that could have been received based on a simple hourly rate. But the firm would make the argument that there are so many complexities, so many things that we have to speculate about. Tobacco companies are 800 wins in with no losses. And so we're taking a chance. And once that condition is satisfied in terms of the contingent fee, the firm will say we're entitled to this. But we know that that wasn't the result. The firm was awarded $100 million plus $775 million that the state had offered them. So that was another example. Now here on page 381, we have sort of a smaller scale example, but it still allows us to look at 1.5. And I think we had set it up this way. We have our client is Ingrid, and she's complaining about some previous representation that she has received. You have an attorney who goes through a number of processes and racks up $60,000 in fees in order to obtain $70,000 in damage. So this is sort of the kicker, and we're looking at the bottom of page 381. When Ingrid got the bill from the lawyer, Colin Horlick, she was aghast. She came to consult us as the attorney about this bill, whether or not this bill was excessive. Is it an unreasonable fee? So the client, I think rightly, points out that even if she ultimately collected the full $70,000 from the landlord to do the required repairs, she would have spent almost that much money in trying to obtain the recovery. So how should we evaluate whether Colin actually has charged an excessive fee? What other information do we need? And then the next question after that is sort of a catch-all question. Apart from 1.5, what duties or obligations has the lawyer violated? So, what about this? Has Colin charged an excessive fee? So those factors listed in 1.5 are not exhaustive. We have to look at a number of things. I think one thing that you see is that you can't look in isolation at whether or not the attorney got a good result. I mean, we saw that in the Fordham case. We have this lawyer who comes up with this novel theory that no one thought about. But, you know, it takes some $50,000 or $60,000 to do that. Gets the client acquitted, but then what about the fee? So we didn't only look at the results, we also looked at what was commonly charged in that jurisdiction. And we noted that what was commonly charged was $10,000 or less. So notwithstanding that novel theory that we had in Fordham, unreasonable fee. So what do we do here? Yes, go ahead.
Well, it seems like this legal question being asked is not novel, or the first in Rule 1.5 says the novelty and difficulty of the question involved is skill to perform the legal question. This doesn't seem like something that would take a crazy amount of skill. So 88 hours on this seems pretty unreasonable to me.
Yeah, why do you think an attorney would do that? I'm just curious. Why do you?
Charge about the hour, I guess.
Yeah. And we're going to get to that sort of, that's some of those factors that were listed. I want to go through those factors and see if have you encountered any of that in practice. But yeah, this hourly rate has a built-in thing with it. You have to be efficient and economical to the client, get the right result, but it's unreasonable to spend like 88 hours on this type of thing. So we look at the novelty of this claim, and it doesn't seem that novel. It seems sort of garden variety. What about that? So I'll put, here's a number of, does it really take 88 hours to obtain this result. This matter is not novel or routine. Can an attorney reasonably charge $60,000 for a $70,000 recovery? Anything else? This is all leading us down the road saying this is unreasonable. So is getting the right result enough? We're beginning to see no, because we want these fees to be reasonable. Is there any argument we can make that this is a reasonable fee? Look at amount. Customarily charged. So, looking at this rule, is there any conceivable argument that could be made that this is reasonable? Probably not. I don't see anything here. So if that's the case, what about the lawyer's performance? So this is a good way to say, were rules other than 1.5 violated? So look at what the attorney did in this case. There's a direct connection between the lawyer's performance and the amount of this fee charge. This next question says, apart from 1.5, has the lawyer violated any other duties to Ingrid under the rules of professional conduct or other law? So you always have to be thinking about this as president. Yes, Mr. Matt.
One thing that jumped out at me in the facts was that he persuaded the landlord's lawyer to participate in mediation. It took a lot of time, but it doesn't say that he discussed that.
Yeah, bad. So what? So that's interesting. So why couldn't I, as a lawyer, say, I'm using my expertise. You told me to do this. This is incidental to the representation. I can check with you about everything. And I'm moving forward. To me, this is just like filing some papers in this matter. What about that?
1.4, talking about the, sort of collaborating with the client on the strategy.
Yeah.
Especially when it's something with an uncertain outcome. Like
That's right.
mediation.
That's right. Type of fee, that's good. And so notice what this does. If you don't have this conversation with your client, this scope of representation is going to be skewed. I mean, you're not on the same page. I mean, you're on the same page on the superficial level. We want to get a recovery from this landlord. But apart from that, you're not on the same page in terms of scope of representation. Indeed, if this is a collaborative relationship, then the client tells us what he or she wants to do and we move forward. So the attorney should have came back to her and said, this is what I'm thinking about doing. There's some costs, there's some benefits to this, some costs to this, some consequences to this, some extra expense to this because we are adopting another process. And so the client should be able to weigh in on that. But what really happened here is, on some level, the client did not get what she paid for. She got an exorbitant bill based upon something she wasn't even consulted about. So persuading the landlord's lawyer to participate in this mediation process was fine, but should have gotten authorization from the client. So that's one thing. Communication, diligence. Now think about that. Diligence is not just working hard. Oh, I worked hard. I just put in 8 hours on this case and I keep billing. Diligence is certainly connected to competence. And so it's not just working hard, it is working in a way that advances the client's interest. And then we also see the scope of representation is out of whack. So this problem illustrates not only that this fee was unreasonable, yes, it was an unreasonable fee, but a number of things that broke down in terms of the way that this attorney performed. So we looked at time, labor, novelties, not really a novel issue. Too much time was really spent if this is a routine issue. Customary fee in the jurisdictional locale is probably out of whack, and the amount involved in results really show us that this is unreasonable because you're spending almost the same amount as the recovery. Spending $60,000 to get a $70,000 recovery. So the lawyer's performance is subpar as well as the fee is unreasonable. Now, a large part of this chapter talks about billing. And sort of starts with this article on page 385 that talks about how lawyers can become unethical bit by bit. And you look at the 0.5 and you shave it up to 0.75, and then you shave it up a little bit more to 1 without doing any work. And so this article really talks about situational ethics. How things may change based upon context. And of course, on page 387, this certainly doesn't happen at every large firm. It's a matter of degree. We talk about culture. But this section in the chapter just goes to talk to you about one of the ramifications of modern day practice. Now, having said that, starting on page 388, there is a large list of things that happen in billing. So those of you who have worked at firms, don't name the firm or the organization or entity or anything. How did you bill your time? Did you notice anything about how billing was done in practice? And I'm really interested in this because when you probably laugh. When I practiced, we had these little, they probably don't even make them anymore. Look, you had these little red books, they were like diaries, and then you write down, and then you give them to your assistant, and she plugs them in. I'm sure now there's a ticker, and you just do it by the computer. computer. But that was a way of timekeeping. So you could see that there could be some discrepancies there if you're not forthright and candid and honest. So, Ms. Paula, yeah, Dan, go ahead.
I know, well, personally, I just clock in and out. I don't have to bill for every, like, specifically what I do.
Uh-huh.
I think the attorneys are a little different. They don't bill every 6 minutes, like I know a lot of places do.
Uh-huh.
But they have to write off what they did during that time. But it's not like every, like, certain amount of increment.
Tell me about write off. What do you mean by writing?
Well, I'm just from what I've seen,
Yeah.
it's kind of just like an Excel sheet, so they'll put the case name and then what they did
Mhm.
on that case, and then they'll move on to the next one, but it's not like every 6 minute type
Yeah.
of thing, what did you do exactly?
Is it more detailed or is it just like research done or?
It's more detailed.
Yeah, that's good. That's good. Anybody else? Yeah, go ahead.
So it was like a software program, and as soon as like I logged into my computer, it came up and the timer would start, and then you would fill in like the client and what you were doing, and then just let the timer run while you were doing things. But if you like got up, you had to turn the timer off.
Oh,
And it was a 6 minute like if I did something for like 5 minutes, it was 6 minute minimum.
Okay. So in terms of billing and your assignments, what did they tell you? Like you go into a partner's office and he said, we've been researching this issue and I don't know if there's anything out there, but I want you to take a look. I've looked at a couple places, I haven't really found anything. Doesn't have to necessarily be on point, but I want something analogous. Did they tell you how much time to spend on that, or would it just go do it, or what about that?
No, because my time would get reviewed like during every billing cycle. So
Okay.
I mean, if I spent more time on it, they would fix it so that the client wouldn't be overbilled because I didn't really know what I was looking at.
Okay, that's good. This is some good stuff. Anybody else? No? What about those of you who work in public interest organizations? Is it done a little bit differently there? Like how? Yeah.
So the place that I worked had a computer system like she was talking about with a bunch of drop-down boxes. So you drop down, select client, and then there was another drop-down box and then select what kind of work you were doing, whether it was research or court appearances, interviews, and that was very detailed.
Okay. And after you fill it out, does anybody check that? Who checks all of that stuff?
So my supervisor checked it again every 2 weeks, and her supervisor checked it once a month.
Okay. Wow, that's good. All right. So, I guess all of these billing practices that you see in the book are like foreign to you, like padding, that's sort of inflating the bill and just putting more in, or sort of changing the hour. The ABA committee, you see on page 388, says an hour is an hour. So that means bill for what was actually worked, not rounding up or out. Creating billing is another thing. So, like, apart from creative billing, you see on page 390. So, lawyers sometimes get into trouble by sort of doing things that aren't necessary. So, you could have a garden variety case and the attorney says, we need 2 briefs in this case, 3 letters, and 5 client interviews. We don't care whatever the case is. We don't care about the facts or anything. We do this in every case. And so just like padding is unethical, creating work for billing is unethical as well. So you see this example on page 390. You have this attorney systematically increasing the bills for work that was not performed. So this is it's in here because this is a fairly high level attorney. He's working at Cravath. He has a PhD. All of this, earns $1 to $5 million a year, is managing in the firm. So he was managing partner of his firm, and he reviewed the time records of all the other lawyers in the firm. And as he reviewed them, he was writing instructions to the bookkeeper as to how many hours should be added to those recorded by the lawyer. So that's what we mean in hours in an hour, don't increase up. And so he was systematically increasing the number of hours billed for work that was not performed. And he was doing this to a federal agency, so you know what's gonna happen. He overbilled a major client by at least $1.4 million. And so he was convicted of mail fraud because when you send out the bills, that's fraud. Sentenced to 33 months in prison. Civil settlement, he had to pay $2.5 million and was disbarred. But it's funny, all of these stories that are really bad behavior, they almost always seem to have a sort of a perverse happy ending. So he's disbarred, loses that. He starts this other company that provides document discovery services to lawyers, and he sells it to Xerox for $174 million. So, wrong message, but still. Another thing is no profits on costs. So, a lawyer can't bill for overhead. No double billing. A lawyer can't sort of say, well, I'll just start all over again and do the same thing again and again and then bill you for it. The theory is, and this is what happens in work relationships, particularly when you're first starting out, you always ask, is there a model or has somebody done it before? That saves the client time and money. And the person that's supervising your work, it saves them time as well. So no billing for recycled work. You're really supposed to pass on the benefit to the client. No churning. Make work that doesn't lead to a result. So you have a partner that says, well, I always do like 4 or 5 depositions, even people who aren't really related to the case, just to get a feel for it. And then we always do 50 hours of research. Just, you know, so that isn't anything that's related, so you're really producing inefficiency. No billing for personal expenses. So I'm on my way to the courthouse and I look down and say, boy, these pants are horrible. I have some pants in the cleaner. Why don't I get them and I'll just charge it to the client account. That's litigation expenses. So that would be unethical, personal expenses. And then one of the major things is charging clients at lawyers' work rates for work done by non-lawyers. You know, mail this letter and then I'm billing my rate on that. And there's even, this is totally outrageous, on page 397, billing to explain the billing. So I'm taking time to sort of fill out my timesheet and explain to the client what they're being charged for, and I'm billing for that because I'm explaining to you and that's taken away from other time. So that would be unethical as well. You see that on top of page 397. Now you see a chart on page 399 of contingency fees. And this explicitly says that it has to be in writing. So contingency fees you can't do contingency fees in criminal cases because of the liberty interest, of course. Can't do it in divorce cases because we don't want lawyers to actually foster discord in families in order to get paid. So, and that would be based upon that percentage. And so you have all of the requirements under 1.5. It has to be in writing, has to be signed by the client. The method has to be clearly spelled out to the client, including how percentages will be calculated and how recovery will be remitted, and then whether or not expenses are deducted before or after. You see on page 400, that makes a difference. In that particular scenario, it's a $4,000 difference depending on when the fee is calculated. this fee is calculated after expenses are subtracted, then the client receives more. Now let's go through this, an impoverished client. Problem 2. And so we have to deal with 1.8. And we're doing 1.8E, but we're gonna go back up to 1.8A because that's really important. It says we shall not enter into a business transaction. We don't want any scenario across these rules where the attorney has a stake in the litigation, except when it might be okay for us to provide legal services. So you can have contingency fees, but just not in criminal cases and divorce. So we're gonna look at 1.8E. So we want to look at this rule and then figure out why do you think we might have a rule like this, 1.8E? So this is one of those shall not. A lawyer shall not provide financial assistance to a client connection pending or contemplated litigation. Except costs and expenses of litigation are okay. Indigent client lawyer may pay court costs. So why do you think we might have this rule? Basically says you can't provide financial assistance except for litigation costs. Well, why do you think we have this type of rule? Yeah, go ahead.
I think the book mentions that, like, the reason why you would have this rule, one of the reasons, is to prevent, like, frivolous litigation. So,
Okay, how would that, yeah, tell me about
so
that.
clients wouldn't, like, come to you with a case, that has no merit in
Right.
order to get financial
So that's one, that's good. So we don't want clients sort of shopping around for attorneys who have a reputation for funding them, and it might be totally frivolous without merit, and the client is just looking to have some money. Anything else? We also don't want, no frivolous suits, of course, and we don't want the attorney to have a stake in this outcome, because that is going to impact the attorney's judgment and competence in those things. So you want to be very careful about that. So notice if you look at comment 10, where this is all spelled out. We don't want a scenario where the attorney is subsidizing a client. So notice, and this is why this isn't a rule, you look in the middle of this comment, it says, apart from clients bringing frivolous suits or attorneys having a stake in the litigation outcome, we want to focus any expenses that the lawyer covers to those relating to the litigation or transaction itself. These dangers do not warrant a prohibition on the lawyer lending a client court costs and litigation expenses, including expenses for medical examinations and the cost of obtaining and presenting such evidence, because those advances are virtually indistinguishable from contingent fees and help ensure access to the courts. So that's why there's so much focus in terms of this exception about litigation or expenses relating to that in and of itself. But that gives us a problem with the rule. How do we figure out what is prohibited subsidizing of a client and simply paying its litigation expenses and helping to move it forward? So this is what this problem sort of illustrates on page 405. So we have a private practice and we have a client, Gerald Mahoney, 62 years old. He lost his job as a security guard, and there is going to be a ADEA age discrimination suit. On page 406, you see that. Primarily because of some of the things that the employer said to Mahoney. It's time to get some younger blood in here, that type of thing. So 62 and 5. Other employees have been fired because of their age, we think, and we think we have a good chance to win this case. The problem says decent chance. The case probably will go on for about 3 months. If he prevails, we think that he would be awarded about $50,000 in damages, and we have a contingency fee. We would get 1/3. We have a contingency agreement that's in writing and comports with everything that we talked about before. Mahoney has no money and could end up homeless. He's been served with an eviction notice. Telephone disconnected because he had no money to pay the phone bill. Not living with relatives. If he's evicted next month, he'll have no place to go. So we know that if our client is evicted, we're going to have a difficult time keeping up with him. And of course, we've talked about this collaborative relationship between the lawyer and client. How will we keep up with him? How will we arrange meetings? How will we keep this matter moving forward? So even if he stays in his apartment, this problem says, the fact that he no longer has a phone will make it difficult for us to prepare for trial. More importantly is that unless he gets some emergency funds while the case is pending, we may not have enough to eat. We want to give him money to help him to get by while the case is pending and avoid his having to drop the case for lack of funds. We want to buy a prepaid cell phone so that you can call him when you need to talk to him about the case. We also want to pay for his rent for the next 3 months so he can be in a stable place and we can meet. And we also want to give him cash for groceries. Can we pay those expenses? Under 1.8E. So we don't want to subsidize the client versus legitimate cost litigation. Okay, can we pay for those things? And we're just under the model rules. There are some states that are a little bit more flexible and say that if you have a client in this situation, that's part of the representation. But we're just talking about under 1.8E. Yeah.
I would say no under these rules, but I think if I were in this situation, I would try to find other resources and help in other ways that weren't directly me paying for
Well,
it.
that's good, that's good. So, you say, I think you're right, no to everything. What about, no, I think that's right. What about the prepaid phone? That could be murky.
I feel like that could pretend, I feel like you could make an argument that it ties into the cost of litigation.
Yeah,
But considering like the context of, you know, that the client would also need help with rent and also need help with groceries, I
Yeah.
feel like it's probably not a good idea.
this prepaid phone isn't gonna be solely for litigation. And so, it's sort of like renting groceries as well. I mean, all of those things are directly related. We want to communicate with them, we want them to have a stable place to stay, we want them to be strong and able to talk to us. But there are other reasons for doing that as well that come close to being subsidized. And so, no. So go ahead. You're about to say you would do other things.
So I would try to find programs that could maybe help, like with groceries, you know, trying to connect him with like local food banks and that sort of thing. And then involving the rent, I would maybe encourage him to talk to the landlord or even see if the client would want me as, you know, to kind of get involved with the landlord to maybe just let them know what was going on.
Mhm.
With like the litigation only being like 3 months out, and if they know that there's a good chance he's gonna come into the money, they may be willing to kind of wait, with that.
Okay. And then what if the landlord says, no, I need my money and all of that, which could happen?
Right. I don't know.
Yeah. You might some type of transition housing. Try to avoid a shelter, but that may be what happens. And so I think you're right, under these rules you couldn't, just because of what we were talking about, and that seems like a harsh result, but that's what we have under the rules. So in light of that, some states have said, when you have this indigent client, they have sort of expanded this, not only for the sole purpose of access to courts, but maintaining the client so that the client can effectively participate in the litigation. So a broader interpretation of what litigation expenses are. So 1.8D, top of page 407. So prior to the conclusion of representation of a client, a lawyer shall not make or negotiate an agreement giving the lawyer literary or media rights to a portrayal or account based in substantial part on information relating to the representation. So again, you see through 1.8, there's this constant proposition that we do not want the lawyer to have a stake in the litigation or matter because that is going to impact competence, diligence, judgment. So think if you have a major trial of the century or something, you're a great attorney with this great reputation, you enter into a literary contract with Simon & Schuster as well as a movie deal with MGM. Because everyone knows this is going to be big. You do that prior to the litigation itself. What's wrong with that? You know, I make the access to justice argument. This client has no money at all. I'm doing this pro bono, and so I know I can't take a contingency fee in this criminal matter. This is even better. At the end of the rainbow, when we get this perfect result that's going to be in the movie, everybody's happy. Criminal defendant gets off and is acquitted. I'm more famous and rich than I ever would be without this, and everything is good. Client agrees to this, informed consent, and we're off. So what about that? What's wrong with that? Why do you think the rule says prior to the representation? You can do it afterwards, but not prior to. That, and then does this rule really work? Go ahead.
I feel like if it's prior to the conclusion, then you're gonna try to like make it more interesting. Like you're probably not gonna like settle it or anything. You're gonna want to like see it through, and it's gonna affect your judgment.
But good. So what do you mean when you say you make it more interesting?
Like if you're hoping that a movie or something's gonna be made, you're not gonna like, I don't know.
I mean, you could do some crazy things. Maybe you have exculpatory evidence. You have it. You've done the research and you have it. And you just, if you present it at this moment in time, it won't even be a trial. They'll just throw it out. And so you stretch it out until 2 or 3 months later, and then you look in your briefcase and say, oh, I can't find it. I have to go back to the office. And then you drive across the freeway, you finally get there, and then you come back to the courthouse and dramatic and say, here it is. That makes a better movie than just saying, we move for directed verdict, Your Honor. They can't prove their case beyond a reasonable doubt. And so that's the outrageous example, but you don't want that impact upon competence, diligence, and more importantly, judgment. Settlement, look on page 410. So 1.8H is important. You cannot prospectively limit liability. You can't insulate yourself from a malpractice. You're not going to malpractice anyway, but you couldn't upfront say, you can't sue me for anything. I'm exercising my professional judgment, and you just have to go along with it. So if you look at the top of page 410, you cannot prospectively limit liability. And so if you look at comment 14 to rule 1.8H, you look, to comment 14, it says, these type of agreements are prohibited unless the client is independently represented in making the agreement, because they are likely to undermine competent and diligent representation. We keep coming back to that. Settling claims. Lawyers shall not settle a claim for liability with an unrepresented client or former client unless the person is informed in writing about the desirability of obtaining independent legal advice. Again, that's important because we want arm's length transaction, and we want that person to have a reasonable opportunity to seek advice and evaluate that settlement. So maybe there's malpractice on the horizon. You say to your client, oh, I think I was wrong on that. Okay, let's settle this. I'll give you $10,000 and we'll move it along. You couldn't do that because you have the unequal power, really. You have more power over this client. You're an agent of the client. We had expertise. We had fiduciary duties, all of these things. And so if we did that, we would have to advise the person in writing about the desirability of seeking and giving a reasonable opportunity to seek independent counsel in settling this matter. Because notice you'd be covering yourself. You're saying, I don't want to commit a malpractice, or even if I have, I want to settle this. So there would have to be an independent, arm's length, neutral third party giving advice on that. Book also makes the point that you cannot generally share profits with a non-lawyer. And we have 1.5E, you look on page 416. 1.5E I want to emphasize is tells us that lawyers not in the same firm may divide a fee, but only if each lawyer assumes joint responsibility. The client is made aware of this arrangement and confirms it in writing, and the fee is reasonable. So either the lawyers perform proportionate services, and it has to be communicated to the lawyer, to the client, or if not performing proportionate services, they have to assume responsibility. That's 1.5E on page 416. So this whole notion of equal responsibility runs through the rule as well. We also know that attorneys, if they're paid by a third party, the attorney must maintain independence. Now turn to page 424. Let's say you want to enter into a business arrangement with a client. I mean, this client's real estate business is really taking off, and you want to be a part of it. And for the last 4 or 5 years, you have represented the client on various matters. And now you say, I want in. And that's going to be interesting. That should raise some concerns, because you're saying, I want in on this matter. I want to be your partner. How would you go about doing that under 1.8A? Another one of those rules that is mandatory but with exceptions. You really should not do this, but. So notice, this is probably the most clear example of an attorney and client being at odds, conflicts with the lawyer's personal or business interests. 1.8a. So this rule is sort of in between what we did before. 1.7 was current clients, 1.9 is former clients, and then this is a specialized type of conflict between the lawyer and client. And it starts off with shall not enter into a business transaction with a client unless so notice this clearly states in 1.8a this proposition that we've been talking about most of the class, and that is we don't want the lawyer to gain a stake in any litigation or matter because that is going to impact independent judgment. So lawyers should not enter into a business transaction with a client or knowingly acquire an ownership, possessory security, or other pecuniary interest adverse to a client unless. So, within the context of this rule, you want to enter into this business relationship with your client who owns a massive real estate business. You see how well it's doing. You've been the lawyer all the time representing the client, and now you want in. You know about 1.8, so what do you do? What do you do? Oh, and I want to enter into this business relationship, and I want to be a partner too. I want some money, and then I want to do a lot of things in that. So how do I deal with that, Ms. Paula?
Well, there's 3 requirements that you have to meet in order to be able to do that. So it has to be the transaction in terms that the lawyer will have, or like the interest the lawyer requires has to be fair and reasonable to the client, and are fully disclosed in writing in a manner that the client can understand.
Okay.
And then the client
deal. You want certain percentages, you want to be able to share in the profits. You also want to maybe represent the real estate company as well. You want to do all of these things. You think it'll be a good deal for you and the client. How would you deal with that under the rule?
Well, you have to probably have an exact plan of how the fees that you want, the percentages you want, how they will be decided, and that those are completely communicated to the client in writing. And then I would probably advise them that they seek other legal counsel to look at it. So then that way, if something is wrong and they don't understand something, they can get that clarified, kind of encourage that, and then
Okay.
just go over the terms again to make sure that they agree.
Okay. Now, why did you go over the terms again? That's interesting.
I guess just to kind of make sure you cover all everything you want. I mean, maybe have them initial each thing so that way they know.
And really, if you think about it, that's really the only way to get informed consent after you do all of this. So notice it builds layer upon layer. If you look on page 424, you have the rule set out. So we shall not enter into a business transaction unless so this transaction that I'm trying to get into, it has to be fair and reasonable terms to the client, fully disclosed and transmitted in writing. So those fair and reasonable terms in writing, desirability of seeking independent counsel in writing, on this particular transaction, and informed consent in writing. Now, it's important to note that, apart from these documentary requirements, you're having conversations all along. I mean, the first one is the approaching, this is the deal, how we're gonna do it. These terms have to be fair and reasonable to the client, transmitted in a way that the client understands, fully disclosed to the client in writing. The client says, oh, this sounds good, let me check. You say, oh yeah, you should, in writing, go see an independent counsel. Give them time to do so as well. The rule doesn't really talk about that, but it's not like you're writing a notice saying, this is in writing, go seek counsel, and that's that. Give them time, and then come back and you have informed consent. And so really after this bill is fully formed, you review it again to say, these are the benefits and advantages. Clearly explain the lawyer's role. Apart from the percentage, if the lawyer wants to be counsel, you have to explain that as well. And you have to say, well, our interests might diverge on some levels. This is like a joint representation. I'm not representing you, I'm representing the real estate entity. And so that could cause problems as well. So you have to fully discuss all of these matters. And so if you look at comment 1, it really talks about our skills and training as lawyers, and we want that to be balanced in this particular relationship. We want to make sure that we are not taking advantage of the client. So 3 writers are required. You see on the top of page 425, that's sort of a checklist that tracks the rule. So you start off with the principle of fairness. Is this fair to the client? Have you fully explained those terms to the client in writing? Then the advice to seek independent counsel in writing. And notice in about, has the client had the chance to get advice from another lawyer? That's not in the rule, but in order for independent advice to be effective and informed consent to be real, the client has to have some time to consider the options. and then has the client consented in informed consent in writing. 427, emphasize this point. Do not ever borrow a penny from client funds that are entrusted to you. Major downfall of many attorneys. Some rationalize it that, well, I'll take money from this client account that you have an obligation to obtain, free and clear and separate of other encumbrances. And you may even be audited randomly. It's a small firm or a large firm. But some attorneys get into problems when they say, well, I'll put it back. If I'm taking it out and putting it back, it's the same thing. It sort of evens out. But taking it out is the violation of the fiduciary duty. So you see that on the top of page 427. .428, a lawyer can prepare an instrument on behalf of a close relative. 1.8c says you can't solicit any substantial gift from a client. That's 1.8c. Sexual relationships with clients are prohibited for obvious reasons. Exploitation, undermining independent judgment, conflicts, how confidences are shared or undermined. And though while not advisable, you see on the top of page 431, sexual relationships are prohibited unless they existed before the lawyer-client relationship began. Now what if you have this situation? The wife is a prosecutor and the husband is a public defender, and they're in the same case. What happens there? How does the conflict work there? Is that a conflict, and then how do we handle it? So the criminal defendant said, well, I'm not waiving, that's your spouse on the other side. What is that? Okay, go ahead.
Yeah, they're gonna have to be recused from the case because the assumption is that they're gonna talk about it at home.
Right. Yeah, well, the assumption is, but if we, yeah. If you're abiding by the rules, then you're not gonna talk to your spouse, right?
No,
Are you saying realistically? Yeah, but,
Yeah, yeah.
but the
Even
pr-
then, you've got like an interest in the outcome.
Mhm.
You know, say like, I won the last 3 cases.
Yeah, there are movies like this, like The Verdict or something. Anyway, so yeah. But I guess I'm suggesting the presumption can work the other way too. You could say that the attorneys are going to adhere to the law. But I think you're right. I mean, the only way out is maybe the criminal defendant unlikely would say, yeah, okay, that's fine. They represent the state, we're against them anyway, that's fine, if they give consent. But what if the client does not give consent, then what? Does the imputation run through the firm? Following up, tell me why.
Well, that's just what the book says. But I was saying because
But tell
the
us.
conflict wouldn't, the adverse conflict wouldn't necessarily be there anymore, even though they work for the same firm. They would have more like a personal stake in the outcome.
There we go. So that's one of those personal conflicts, not imputed to the firm. And so the the obvious thing to do would just get other attorneys. I mean, the prosecution gets somebody else, or the defense gets someone else. And that's one of those personal conflicts, not really relating from a particular matter that they were involved in before, but their relationship itself. So, see that at the top of page 432. So if one of the clients is not willing to consent, another lawyer in the firm may take over the representation. And you know, the criminal defendant might say, well, it's still the state and they're still against me, and the spouse still represents the state, just not on this case. But the court wouldn't see that as a conflict. That's just personal. Same thing at the top of page 433. This personal interest conflict. So you have a partner in the firm who has a certain political belief, but the firm takes on a client that is sort of opposed to that political belief. That is personal as well and would not be imputed to the firm. That attorney just would not work on. Conflict would not be imputed to the other lawyers in the firm so long as the conflicted lawyer does not do any work on the matter. Now, how is that different than the Thermos hypothetical on page 433? So at the end of this chapter, it says, what we want to emphasize is that you have to look at the facts and not make what it says, categorical distinctions. So the loyalty interest might change in a small firm context. Look at, so the first hypo on the top of page 433 talks about a law firm wants to represent an organization that advocates for rights of Palestinians in Israel. Another lawyer in the firm does not believe in that. He believes in something else politically. So those lawyers, that lawyer's personal conflict would not be imputed to the firm. That's something that's personal, not related to a matter or a former firm or client. So that wouldn't be imputed. The only requirement is, since it's not imputed to the firm, is that someone else work on it. He would be limited because of his personal beliefs. How is the Thermos example different? The first one is a personal conflict, not imputed. The second one is different. So we have, it says, one lawyer in a firm wishes to represent a worker at a Thermos factory who was injured on a job. So this is the firm. And then one of the lawyers in the firm actually owns the Thermos factory, therefore not able to handle the suit. How is that different? And then the book goes on to say that that's imputed to the firm. What's the difference between this personal conflict, which isn't imputed, and this second one, which is imputed? Yeah, go ahead, Ms. Madden, I'm sorry.
It seems like the first one, there's not as much at stake for the lawyer with the potential conflict, because it's like a personal political belief, whereas, and therefore, not, there isn't as much pressure for the other attorneys to show like allegiance to that attorney, whereas in the second one, there's more at stake there for the lawyer, also a partner, it says, who owns the factory and could take a substantial hit.
That's right. And so out of that comes the fact that the representation may be materially limited. So even if they did take this case on, they will be sort of hesitant to go as far as they should because they'll be hurting one of their own partners. But then the book goes on to talk about how loyalty interests may change in a small firm context. So it says the result might be different if, in this first example of the Palestinian personal interest, it involved a small firm of lawyers, and the lawyer with the conflict had lost a family member to a Palestinian suicide bomb. The loyalty of the other lawyers to the first lawyer might require imputation of the conflict for the same reason as the second example. So if there are scenarios where the personal conflict can turn into something that's more substantive that could be imputed to the firm. And that's what Mr. Manning was talking about. It seems more is at stake. And so you have to look at what's at stake in these factors. So that's chapter 9. When we come back, we're going to do chapter 10, and that's going to be the last conflicts chapter, conflict issues for government lawyers and judges. So a government lawyer is going to be moving to a private firm, or a private lawyer is moving to a government firm. We'll look at that. One